Hi, my name is Tiffany Flowers. Welcome to the Know Your Rights training. I am coming to you live from Baltimore, Maryland. I'm a Black woman wearing tortoiseshell glasses with colorful fingernails and a hot pink sweater. And again, welcome. I want to talk to you a little bit about Day Without Us and why it's so important to take this training tonight. September 30th is the 46th anniversary of the Hyde Amendment and 3 days before the start of the next Supreme Court session. We're taking action on that day to demand immediate action to restore and protect reproductive justice for all. Reproductive is definitely a workplace issue. Because a lot of folks get their health care from their employers, at will employment laws mean that our non union pregnant workers regularly face discrimination. And if the Supreme Court can strip pregnant people of their freedoms, they can do the same for all of our freedoms. And that is exactly what they're trying to do. The Day Without Us grew out of a text thread between a group of Black organizers who were sick and tired of the lack of response to the Dobbs decision. The text thread led us to reproductive justice, civil rights, power building, and social justice organizations, and they agreed that the time to take action is right now. On September 30th, we're removing ourselves. We're removing ourselves from our workplaces and refusing to spend money, especially at companies that fund elected officials who are stripping us of our rights. Instead of giving our money and our labor and power to the bosses, we will instead join together to be in solidarity with each other, to learn from each other, and to take action in our local communities. We have the right to remove ourselves, make no mistake about it. On 9/30, it's very important that we understand where our rights come from and how to exercise them. We're so grateful to one of our national partners, the National Legal Advocacy Network, NLAN for short, for joining us tonight to talk about our rights and to talk about what exact rights we have to take action. It's truly my honor to introduce the NLAN team. Take it away, Lorraine, Tyler, and team. We're so happy to have you.
Hi, everyone. Thank you for joining us today for our Know Your Rights training in preparation for this Friday, September 3rd's Day Without Us, National Day of Actions. My name is Sheila Madali, and I'm the Executive Director of the National Legal Advocacy Network. The National Legal Advocacy Network is a legal nonprofit organization dedicated to shifting the balance of power towards greater equity in our economy and society through organizing, empowering marginalized people, and challenging entrenched racism, sexual harassment, exploitative work practices, and predatory business schemes. We do this by working in deep partnership with base-building organizations throughout the country to democratize the law, bring strategic litigation, and build people power. Today, I'm going to pass it over to my colleagues, Tyler Sprague, staff attorney at NLAN, and Lorraine Sands, legal organizer at NLAN, to tell you a little bit about your rights to participate in A Day Without Us on Friday, September 30th.
Thanks, Sheila. Day Without Us, taking place on Friday, September 30th, 2022, is a day of action for reproductive justice and recognition of the 46th anniversary of the Hyde Amendment, which bans federal Medicaid funding for abortion services and effectively bars millions of poor and working class people from accessing full reproductive health care. People who work in low-wage industries, particularly people of color, face intersecting oppressions, including workplaces characterized by precarity, poverty wages, discrimination, lack of benefits, and more. The reality is that the rights available to working people in this country are subpar, and those that do exist do not apply to all workers uniformly. Today, we will focus on the right to engage in a one-day work stoppage, like Day Without Us. Let's talk about what we will cover specifically. We will cover the right to engage in a day of action under the National Labor Relations Act. Within that, we will talk about who is covered, what is covered, unfair labor practices, and remedies. And we will also discuss best practices for engaging in a day of action. Before we get into the legal information, we need to provide a disclaimer. This workshop is intended to provide attendees with general information about relevant employment laws. It's important to note that the laws are fact-specific, often changing, and may contain exceptions to the general rules that we can't get into today. Therefore, this information should not be relied on as legal advice. If you are dealing with a specific issue, you may want to get in touch with an attorney in your local area. However, the purpose of today's presentation is to give you a basic understanding of your rights as you consider participation in Day Without Us. I'll now pass to my colleague Tyler to kick us off.
Thanks, Lorraine. Let's talk about who is and who isn't covered under the National Labor Relations Act, also known as the NLRA. The NLRA is the law that establishes the right for two or more employees to act collectively to improve workplace conditions. Workers are covered by the NLRA unless they are public sector employees, such as people who work for a government agency or body, supervisors. As a manager or supervisor, you can choose to participate, but it is important to note that you do not have the legal protections afforded by the NLRA. Independent contractors. An independent contractor is a self-employed person or entity contracted to perform for or provide services to another person or entity. Examples of independent contractors include rideshare drivers, electricians, and plumbers. Note that an independent contractor will fill out a W-9 instead of a W-4 form. Next, domestic workers, such as people who perform work in a private household or households. Agricultural workers, such as farm workers and animal breeders. Railway and airline workers, and people employed by their parents or spouses. Now that we've talked about who is and who isn't covered under the NLRA, let's get into what is covered under the NLRA. The NLRA prohibits employers from taking adverse employment action against employees who engage in protected concerted activity for their mutual aid or protection. Examples of protected concerted activity are two or more employees addressing their employer about improving their pay, two or more employees discussing work-related issues beyond pay, such as health and safety, or an employee speaking to an employer on behalf of one or more coworkers about improving workplace conditions. The NLRA also includes protection against employer retaliation for workers engaged in work stoppage or strikes. There are two types of strikes, economic and non-economic. Economic strikes involve wage and benefit related work issues. Non-economic involves non-wage and benefit work-related issues, such as health and safety and unfair labor practices. In our case, participation in Day Without Us would likely fall into non-economic categories. Section 7's Mutual Aid or Protection Clause extends to concerted political advocacy when the subject matter of that advocacy relates to employees' working conditions. The focus is on the purpose of concerted activity. There must be a connection between the activity and work-related concerns. In the past, the NLRB and the Supreme Court have found that political protests, including days of action, can qualify as protected concerted activity under Section 7 of the NLRA. For example, on May 1st, 2006, millions protested in support of a Day Without Immigrants, a national boycott that protested anti-immigrant legislation, which would have classified undocumented immigrants as felons. Immigrants and others attended rallies and abstained from working, shopping, and attending school to demonstrate the importance of immigrants to the economy. The NLRB found that workers' participation in the day of action fell within the scope of mutual aid or protection because the protest concerned legislation that directly impacted the employment of undocumented immigrants. On February 16, 2017, millions protested in response to a revival of workplace raids and deportation. The NLRB found that the protests were related to workplace concerns because the policies had the potential to diminish undocumented workers' employment opportunities. Another example would be the Supreme Court case Eastex Incorporated versus the NLRB. The Supreme Court in Eastex Incorporated versus NLRB discussed the scope of Section 7's mutual aid or protection language. The issue in Eastex was whether an employer who prevented its employees from distributing a newsletter that criticized the president's veto of an increase in federal minimum wage violated Section 7 of the NLRA. The court concluded that all of the material in the newsletter was reasonably related to the employees' jobs and conditions as employees in the place, and therefore fell within the scope of mutual aid or protection. So based on the decisions of the NLRB and the Supreme Court, we believe participation in Day Without Us falls within the scope of mutual aid or protection because reproductive health care is linked to workplace conditions, opportunities for advancement, and healthcare options of pregnancy-capable people in the labor market. For example, workers with access to reproductive health care tend to have better working conditions, including opportunities for advancement and lower rates of occupational segregation. Additionally, reproductive rights and healthcare access increases workers' job continuity. Lastly, people who work in precarious employment situations, such as temporary staffing workers, domestic workers, and independent contractors, often lack employer-provided healthcare and are more likely to rely on federally provided benefits like Medicaid. Now, I'll pass it back to Lorraine to talk to us about unfair labor practices and remedies.
Thanks, Tyler. An unfair labor practice refers to any action taken by an employer that discriminates or retaliates against workers participating in protected concerted activity. Examples of unlawful actions that an employer might take include discharging, suspending, locking out, or laying off workers. For example, like firing you when you return to work on October 1st or your next scheduled shift. Also included is demoting, disciplining, or taking any other adverse actions, such as cutting your hours, changing your work location, or changing your shift. Lastly, it also includes imposing a burden on those who participated in the day of action and/or granting a benefit to those who didn't. For example, if they treat you as a new employee, make you reapply, and lose seniority. If an employer engages in any of these unlawful actions, you can file a ULP charge. The National Labor Relations Board is the agency that enforces the National Labor Relations Act. If your employer has engaged in an unfair labor practice by discriminating or retaliating against you for participating, you can file a charge against your employer. This charge can be filed on your own. You do not need attorney representation to do so. The process is that you file the charge, the NLRB investigates, and if they find merit to the charge, they'll work to facilitate a settlement or take action against the employer. Potential remedies from filing a charge with the NLRB include reinstatement and back pay for discharged workers, and/or an employer being required to post a notice stating that they won't violate the law. Now that we've covered the legal landscape, let's talk about some best practices for engaging in a work stoppage. Before the day of action, make sure that your work performance is stellar so that there is no other excuse for retaliation. Get support of your coworkers. There is power in numbers. If you're planning on participating in Friday's action, see if your coworkers are also interested. If you have a union, engage your union. Talk to them about the day of action. Providing notice and intent for one-day work stoppage. This includes delivering a document to your employer or manager stating an intent to participate in a day of action beforehand. Certainly before the day of action itself, but at least the night before or morning of. So not in the middle of your scheduled shift or after the fact. In that notice, include details of when the day is and when you're returning to work, and also make clear that reproductive justice is a workplace concern. We will go over the template call-out letter that Day Without Us provided in the following slide. Also, best practice is return to work on October 1st or your next scheduled shift. If coworkers participated with you, return together. Also, document your treatment in the days and weeks after the strike or work stoppage. Is there any discrimination or retaliation that takes place? Are you treated the same as employees who did not participate in the work stoppage? These are questions to ask yourself. Lastly, prepare to have support for delegation, someone walking you into work, legal action, like filing a ULP charge, or organizing action, such as circulating a petition if you're retaliated against. Here's the template call-out letter provided by Day Without Us. It clearly states the date of the action, the intent for a one-day work stoppage. It makes clear the connection between the day of action and your workplace conditions. It states that you will return to work on October 1st or your next scheduled shift. It includes anti-retaliatory language, and it lets your employer know that you are prepared to take action if your legal rights are violated. That's all we've got for you today. We want to thank the organizers and all of you participating in this training and for considering participating in Day Without Us. Reproductive justice is an economic justice issue. It is no surprise or coincidence that those who are most impacted by the assaults on reproductive freedom are poor and working class immigrants and people of color who are disproportionately employed in low-wage industries characterized by precarity and lack of benefits. We hope the overview of the right to participate in a work stoppage gives those participating in Friday's action the knowledge and power to do so safely and boldly. Thank you.